All right, people, one of the most important things that I can help you with is how to stay out of their courts. And I did a, staying out of their courts part one. Watch that one first, and now we're going to start to drill down into the individual parts and start filling in some gaps for some people and clarifying some stuff. So what's first thing you want to know is basically, listen, that the court of record is your best friend. Look in your state for courts of record. Pennsylvania, I'll show you the one statute there actually comes out and states that every court of Pennsylvania is a court of record that proceeds according to the common law. Now, I know there's many other states out there that have that. They'll actually come out and state that these are courts of record, and they'll specify which courts are courts of record. But bottom line is, even in the federal Constitution, it doesn't matter really what your states have. The federal Constitution is the supreme law of the land, and we'll go over that also. And listen, this is a common law country. I don't care what these petty Fagerscheister or judges and attorneys tell you. This is a common law country. Okay, this whole statutory system that they set up, that's their little scheme. Okay, we're still a common law country. They don't want you to believe that or understand that, but they're the facts. We're still a common law country. It's in the 7th Amendment, and we'll go over that too. So court of record is one of the most important tools that you have to stay out of their courts, and we're going to go over what that exactly is. And the main thing that you want to know about a court of record is it proceeds according to the common law, not laws, statutes, codes, and ordinances. The common law is not written down, okay? And we'll go over exactly what common law is. We'll read the definition. But when you see that your state proceeds according proceeds according to a court of record, here are the key elements of a court of record. Power to fine or imprison for contempt. Guess what? These little traffic courts and all, they don't have power to imprison you or to fine you. And anything they do, if they do anything like that, total violation of law of what they're doing. I'm not saying it doesn't happen. Listen, these judges and these cops they're out of control. They think they can do anything they want. But I'm going to show you, they really have no power to fine or imprison for contempt. It keeps a record of the proceedings. Now, what that means is just not that they got a video recorder running or an audio recording running. Keeps a record of proceedings means that the documents you're filing into that case, if you were involved in a case and you didn't know how to stay out of court and you got involved in this case, that means the paperwork you file into this proceeding, your affidavits. So anything you file into this proceeding, there's a record for that hearing that could be looked over afterwards, that could be checked. So that's what they mean by keeps a record. And you'll hear people, basically these judges and these petty Fagerscheister attorneys, they'll say, oh, well, this hearing's being recorded. Just because there's a videotape out there with a recording, that's not going to help you, even if you're in their courts to do an appeal. Because the only thing that the appeal court looks at is the court record, the actual documents in the court, what was done. That videotape is not going to help you. You need the documents in the record. So that's what they mean by keeps a record of the proceedings. Look at this. This is your friend here. Proceeding according to the common law, not statutes or codes. So common law and statutory courts they're opposites of each other. Okay? Common law is not written down. Statutes, codes, ordinances, and laws are all written down. The tribunal, which is the jury, is independent of the magistrate, which is the judge. Now, you go in a lot of these courts, and the judge is the jury. He's making all the decisions. And we already know how corrupt the judges are, so you don't have a snowball's chance in hell. So if you're in a proceeding with the judge, the judge who's getting a percentage of of whatever they can extort from you, he's going to get a little piece of that. And the major conflict there. So listen, you don't want him to be. You want at worst you want an independent jury, even if you have a judge deciding the law and the jury deciding the facts. And it generally has a seal. And I looked at this, and this is listed as optional. And it's funny, is I never really thought too much of this one. It's sort of like a throwaway. Until I seen one come from a traffic court in media, and they didn't even have a seal. They had a picture that looked like the Pennsylvania coat of arms. There was no writing around it, and they were calling that their seal, I guess. But I don't know whose seal it was. There's all kinds of different fictional parties listed on there, and nobody was taking credit for the seal. So their proceeding didn't even have a seal. Now, here's another one that confused a lot of people. No fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. That means there's no appeals. And we're going to go over, I know this has been confusing for some people when you read the Seventh Amendment, and we're going to clarify that. But there are no appeals in a common law court. And when that jury makes their decision, no facts that they decided on can be overturned or re-examined by any court in the United States, including the Supreme Court. So they can't even do anything with that. But there are remedies for a matter like that, and we'll look at that later. So you can think of courts. There's sort of three types of courts. There's administrative/commercial courts. These are the courts that they're getting you in with traffic tickets and these little, trash citation violations or mask violations. These are administrative courts. And what they're doing with you is they're actually claiming that you're part of their administration, because they're claiming you're a subject or a resident or a citizen of their county, their borough, their township. And what they're doing is, remember we talked about that hierarchy. It's God created man, man created government, and government created corporations. Man created government for one reason: to protect his rights, not to rule over them and be tyrants, which they've turned into. So just remember that hierarchy. Don't let them lower your status by calling you defendant. I mean, that's why they put in that paperwork. Even when you get a traffic citation, you're listed as a defendant. Now, and I'm going to tell you, there's no way you can be a defendant because there's no one you're defending against. You can't defend yourself against the corporation. You can't defend yourself against Mickey Mouse or Donald Duck. And there's nothing to defend against. In other words, there's no valid cause of action before the court because there's generally never a damaged party. It's basically the lawyer speaking for the people of the Commonwealth of Pennsylvania, which we know is ridiculous because there's no such thing as the people. Because I can't meet the people. I can't speak to the people. I can't bring them into court and question the people. And when you say the people, you're talking about 25% of the people, 50%, 75%. I'm one of the people. My family's one of the people. Are they suing me too? The whole thing's fraud. So there is no the people. So, and over the years, listen, they've blended these things together, these courts, these administrative and judicial courts. They've blended them together. And like a judicial court, what a judicial court is, when I say judicial court, these are their standard courts. These are statutory courts. And in a statutory court, the judge decides the law, okay? The jury decides the facts. So the judge will instruct the jury, listen, here's the law, and if he did this, according to the law, you got to find him guilty. So he'll instruct the jury on what to do, and the jury decides the facts. Now, if you've got smart people on the jury, which that's even debatable too, because listen, if you don't know enough to get out of jury duty, I'm a little hesitant to having you deciding my freedom, okay? I mean, jury duty, if you don't want to go to jury duty, that thing they send you is not a summons. By any definition, it's not a summons. I take it up, I tear it up, and I throw it in the trash. I don't want to be a part of their statutory system. I'll be a part of a real jury, a common law jury, but I'm not going to participate in their fraud. But I have nothing against people that do want to participate, because there are people that want to get on these juries and nullify the jury, and I think that's great. I mean, if you've got the time to do this, because listen, some people take a hit by going to jury duty because they got to leave their job and they're not compensated for leaving the job for however long this jury takes. So if you want to get out of that, just take the thing they call summons and rip it up and throw it in the trash. And you never got it because it was never served to you, number one. And number two, nobody can summon you to be anywhere. I mean, if they could summon you to be somewhere, then you're their property. Like if I can make you be somewhere because I said so, and somebody stuck a title on my head because they call me judge, well, then you'd be my property. So you don't have to go to jury duty. But if you've got time and you want to participate in the jury, that's great. I mean, go there and then you can be a true patriot. And if they're, regardless of what that judge says the law is, you can nullify that jury. Yeah, and that's what jury nullification is. It's someone that says, listen, I don't care what you say the law is. You can't make me decide anything. I can decide that I don't buy this. I don't buy this law, and I'm going to vote no. Where everybody else is voting for conviction, I'm going to vote no. So if you've got time, do it. But if you don't want to go, you don't have to go to these things. So like I said, over the years, they've blended these together. And listen, they've done that for profit. They're able to get more cases heard, and it's less personnel they have to hire. So it's more money. It's just like any other business. Fewer personnel, more money to make for the corporation. So that's why they've blended these things together. And so listen, you can't have a court that proceeds according to the common law. Like Pennsylvania states, every court of Pennsylvania is a court of record that proceeds according to the common law. So you can't have a court that proceeds according to the common law if they're citing written laws and statutes that are allowing these pettifogger shyster attorneys to act and speak for fictitious plaintiffs. That's not the common law. An attorney speaking for a fiction is not the common law. Common law is common sense. Mickey Mouse and Donald Duck don't exist. So an attorney cannot speak for Mickey Mouse or Donald Duck, and he can't speak for the county or the borough or the township. That's as far away from common law as you can get by following these laws, statutes, and codes, and attorneys speaking for fictions. All right. So like I said, they've blended these together for purely financial reasons for profit. And it's actually stated that courts of equity, which pretty much are every administrative court, are not in general courts of record. Their decrees touch the person, not lands or goods. Very key phrase here. Their decrees touch the person, not lands or goods. So in order to touch the person, you got to have jurisdiction over the person. And we're going to cover that, how courts attempt to get jurisdiction over the person, you. So there's two types of matters. There's civil matters and there's criminal matters. All right. So civil matters, they require a damaged or harmed party to provide a verified claim stating that they were damaged and how they were damaged by the stated party, whoever they're claiming damaged them. And what verified means, it's made under penalty of perjury. That listen, that they're writing this down saying you violated a right or you harmed or damaged them in some way, and that they're willing to go to jail for what they're writing down. That's a verified claim. Criminal matters, they require what's called a corpus delicti. And what that is, that's Latin basically, but what it means is the body of the crime. And that's also your friend in these matters, because these people have created crimes on paper. That's not a crime. If just because you don't file something on a piece of paper is not a crime. Crimes need victims. And that's what corpus delicti means. It means the body of the crime. In other words, there has to be a victim that has been harmed or damaged by something you did or didn't do. And if there's no victim pleading a violation of a right or that's been damaged or harmed, there's no corpus delicti. And we're going to get into how to use that against them too. Now, let's look at judicial power and the flaws of their actions, of what they do. Listen, judicial power is the authority vested in the judges. The Constitution of the United States declares that the judicial power of the United States shall be vested in one Supreme Court. Okay? And in such inferior courts as the Congress may from time to time ordain and establish. Well, guess what? We're going to go over what our inferior courts are. All these traffic courts and these little tax courts, these are inferior courts. And you're going to learn how to use this stuff against them and how not to show up to their courts by putting this stuff in your paperwork and banging them over the head with it. So the main thing you need to know, all courts except Supreme Courts are inferior courts. And let's look what an inferior court is. An inferior court, by this term, are understood all courts except the Supreme Courts, which we just covered there. An inferior court is a court of limited jurisdiction, and it must appear on the face of its proceedings. And by proceedings, it means pleadings. Pleadings are what that attorney writes up, the complaint against you, or the claim, or the lien. They're his pleadings. And so it must appear on the face of the proceedings that it has jurisdiction, or its proceedings will be void. Let me tell you something. These courts rarely ever have jurisdiction. How about almost never? Unless you've damaged and actually harmed somebody, then it's a whole different ballgame. Then it can claim jurisdiction. But if you haven't harmed or damaged another man or woman, this court can never get jurisdiction over you. This is one of the reasons I don't show up to these little kangaroo courts. So this means the attorney's pleading that's filed against you, let's correct that, must be sufficient to grant the court personal and subject matter jurisdiction over the matter before the court. Let's look at personal jurisdiction. Personal jurisdiction means authority over the person. That's you. It's you and me, okay? Subject matter jurisdiction means authority over the matter that's before the court. Now, they like to confuse you with subject matter jurisdiction because you'll hear a court state, we can hear traffic citation matters. That's called venue. If they can hear that type of matter, that's called venue. That's not subject matter. Just because they can hear a certain type of matter doesn't mean that they can hear your matter, because your matter is going to require basically a real party on the other side that is standing. So just because they can hear a traffic citation matter doesn't mean that they can hear your traffic citation matter. And listen, courts attempt to get personal jurisdiction through service of process. That's when that guy shows up at your house, he knocks on your door and he says, Mr. Fagioli, you've been served. And what he'll hand you is a copy of the complaint, and there'll be a copy of the summons in there to summons you to court, the day and the time you've got to come up to court to go to court to defend yourself. So that's how a court attempts to get personal jurisdiction. Now that could still be challenged even when you get served. Just because you get served doesn't mean they get personal jurisdiction. You could still challenge that through paperwork. But that's the court's attempt to gain personal jurisdiction over you. That's what the process server is there for. That's why these people have these jobs and they charge you $80 to $100 to come serve you. All right? Personal jurisdiction's not gathered, or they can't even attempt to get personal jurisdiction through mailing you a letter with a regular stamp on there. Because, geez, if we could start legal proceedings by just mailing people letters with stamps, why would we have process servers? Why would I pay a guy $80 or $100 when I could stick a stamp on an envelope and stick it in the mail and have him served? So right there, when you get a mailing to your house from a traffic court, from a local tax court, whatever, they don't have personal jurisdiction at that stage. They failed at getting personal jurisdiction. For them even to attempt to get personal jurisdiction, they must give you service of process. So if there's nobody knocked on your door, handed you a complaint or a summons, they don't have personal jurisdiction in this matter. Strike one, okay? Courts can only gain subject matter jurisdiction if there is a party with standing that has submitted a pleading verifying that they had a right violated or that they've been harmed or damaged, which was a direct causation of something you did or didn't do. Now, we just talked about subject matter jurisdiction. Just because they could hear a certain matter, a tax matter, or a traffic citation matter, doesn't mean that they can hear your matter, because there's got to be a party with standing. In other words, there has to be a party that had a right violated or has been damaged. What that means, standing. If there's no party with standing, there's no subject matter jurisdiction for the court. The court, any court to proceed, needs both personal jurisdiction and subject matter jurisdiction. If they don't have either one of them, they can't proceed. And if there are flaws with either one of them, personal jurisdiction or subject matter jurisdiction, they can't proceed. They can't hear the matter. Strike two, we're going to hit them with. Now, we said there's no corpus delicti, meaning there's no victim who's been damaged in this matter. These are flaws that you're going to stick in your affidavits, your affidavit of fact, that you're going to bang them over the head with. And we also know that there's no verified claim. In other words, let's go to corpus delicti. There's no victim. Let's go back to that. We know that the Commonwealth of Pennsylvania is a fiction. Okay, there's no Mr. and Mrs. Commonwealth of Pennsylvania is going to walk into that courtroom, okay, and testify. Not going to happen, okay? So there's nobody that's been damaged. That's a fact. We know that. And pettifogger shyster that's speaking and acting for that fiction, he committed a crime against you by just filing that paperwork and listing that party, that fictitious plaintiff, as a litigant against you. That's a crime, and we're going to go dig into that too. So there's no corpus delicti, meaning there's no victim in this matter. There's also no verified claim. In other words, the Commonwealth of Pennsylvania can't verify anything. Doesn't have a brain, doesn't have arms, doesn't have a body. It can't verify anything. So there's no verified claim before this court. That means, no one signed a statement under penalty of perjury that you harmed or you damaged them in some way. So now we know there's no body, there's no crime, and we know that that would basically cover criminal here, this one, and this would cover civil. There's no verified claim, meaning no one signed a statement under penalty of perjury that you harmed or damaged them. So there's no crime and there's no civil matter here before this court. So in other words, there exists no cause of action to bring you into court. Let me put that, change that, fix that. See, I write these on the fly, so there's little misspellings and I'll miss things here. But so there exists no cause of action to bring you into court. Now, we already talked about there's no personal jurisdiction, there's no subject matter jurisdiction, there's no victim, and there's no verified claim before the court. There are 4 strikes right there. Like I said, you can't damage the fiction listed as the plaintiff. So, listen, remember we talked about these are inferior courts. They can only get jurisdiction through the sufficiency of that attorney's pleading. Well, the attorney's pleading is complete fraud. It's insufficient. That's why I use that one document that they call deficiencies and irregularities. I take their document, I circle everything that's fraud on it, and I number it. And then on a separate sheet, I transfer the number over and I state, this is fraud because of this is fraud because of this, and I just go down and I take the document apart. And I welcome anyone from the court or the attorney to step up and challenge me, because I'll bang them over the head with it. They don't have a shot at supporting that document, because that whole thing's fraud. So, listen, there's got to be a real man or woman for this court to get subject matter jurisdiction or personal jurisdiction over you. They don't have it. They never have it. So this is how I'm staying out of their courts. I'm highlighting these things in my paperwork, in my affidavit of fact. And let's go talk about the pettifogger shyster attorney. Listen, it's always the attorney moving these matters against you. This is, to me, like I said, the Bar Association is the most evil association ever created. So the attorney never has jurisdiction in this matter. He never has authority. Jurisdiction means control over, authority over. Just because he's got a bar card and somebody hired him does not give him authority over you. The individual that hired that attorney, he's their counsel. He can talk to them and give them advice all he wants. Just because somebody hired this guy, it doesn't give him any rights to do things to you, because he don't have jurisdiction over you, he don't have authority over you, and he don't have standing in the matter. And standing means that you had to have a right violated, or you had to be harmed or damaged in some way. Well, I'm pretty sure you didn't damage or harm Mr. Attorney, so he don't have standing in this matter. Also, his biggest flaw in this matter, he's got no personal knowledge of anything that's going on in this matter. That means everything he filed against you paperwork-wise, including the initial thing he got from the court, which was generated because of what he did, it's hearsay. Right? Not only is it hearsay, these are crimes he's doing, he's committing here. So look, an attorney that's proceeding against you, he's using hearsay. Of any personal knowledge of anything in his documents, that was told to him by somebody. And if he's citing rules, statutes, codes, or laws on that document against you, well, guess what? Was Mr. Attorney there when they wrote that law, statute, code, or ordinance? No. He wasn't present when that was written. So he has no personal knowledge of that law, statute, code, or ordinance. So for him to cite that law, statute, code, or ordinance against you, it's nothing more than his opinion. In other words, it's hearsay. Opinions are hearsay. He's got no facts that law, statute, code, or ordinance applies to you. So not only is it a violation of the rules of professional conduct that bind him, and this is what we bang him with the bar grievances, every state has a rules of professional conduct. And in there, go download Brett's document in the Be Free folder, download the Texas version, that's the one Brett did, and go look for these rules of professional conduct, because when you get this paperwork from this guy, he's violating a ton of things against you. Go bang him over the head, as Brett would say. Go ring the insurance bell. Go ring the bell by filing a bar grievance against him. So now he's in violation of the rules of professional conduct, and he's also always trying to talk about things as in non-compliance, because their Achilles heel is insurance. So instead of saying you violated the law or you violated this, instead of using violated, start using non-compliant. You're non-compliant with the Constitution. You're non-compliant with the laws. You're non-compliant with the state and federal Constitution and the laws that of the state that bind the attorney. Now, the reason you want to talk is non-compliance. Listen, these insurance companies are ruthless. We know that. Insurance companies will always look for a loophole not to pay a claim. Okay? That's what they do. So if Mr. Attorney is acting outside of these rules and the Constitution and the laws of the state, If he's in non-compliance to those rules, guess what the insurance company's probably going to do with Mr. Attorney? Mr. Attorney, you're in non-compliance to this, and this, and listen, this man or woman filed this claim against you. We're not going to pay that claim if you get sued and you get a judgment against you. Or they're going to shoot his insurance rates up to the roof. All right. So this is why we file claims against the attorney too. If he wants to get involved in the matter, like you have an attorney file something against you, you got your affidavit process, you're fire it right back at him. In other words, Mr. Attorney, you want to get involved in the party? Come on in, sir. Here's some affidavits, and I got to file notice of claim against you too. And on top of the bar agreements, I'm going to make a $250,000 claim against you. So now Mr. Attorney got a bar agreement. He's got to tell the Bar Association was filed against him. And now you file your notice of claim against him, supported by your affidavits, your $250,000 claim. And he's got to tell the insurance company, this crazy man just filed this claim against me. Now the insurance company's not real happy with Mr. Attorney, because if he's in non-compliance of this, they're either going to get stuck with the bill or they're going to dump him like a hot coal. They're just going to drop him because he's a liability for them, right? And they know he's a liability now. And just because, by the way, you got him lined up with the bar grievance and the claim, you're going to ring his insurance bell. His insurance is going to go up. He's going to remember who you are. And you're not done with Mr. Attorney. We have all kinds of other remedies against Mr. Attorney later. Because we all know that there's the Commonwealth of Pennsylvania, they're not coming in to save Mr. Attorney. There is no Commonwealth of Pennsylvania. So if he runs from the case and they bring another attorney in, welcome to the party. Go serve the new attorney. And it's just you, like a case of whack-a-moles, basically, a game of whack-a-mole. They stick their head up, you bang them back down. Everyone sticks their head up, you bang them back down. You just start moving paperwork against them, okay? Now, listen, the attorneys are in non-compliance to the Constitution and laws. They're operating outside of their insurance policies. So, think about it this way. Just as you'd be if you got in your car drunk and you hit someone, your insurance company's not going to pay that claim because you're in non-compliance of your insurance policy. And listen, Mr. Attorney, like we said, when he's acting outside of the law, statutes, codes, and ordinances and the constitutions, Mr. Attorney's not in compliance, and the insurance company has every right to not pay any claims that are filed against Mr. Attorney. And they have every right to probably raise his insurance because now he's a liability. Not only has he had claims filed against him, he's not even following his own rules. The laws he's not following. So now the insurance company looks at him and goes, this guy's not even following the laws. This guy's a danger. My God, if this guy's going to bang him for $250,000, how many other people are going to line up and bang this guy? So good chance Mr. Attorney's insurance is going to go up. Or, if he's had multiple bar agreements filed against him, good chance he's not going to be an attorney because no one's going to cover him. So it's a good way to make a parasite go away. That guy's been stealing from the people for years. Now look, courts of the United States and courts of your state also. Now here in Pennsylvania, they just come out and admit it, right in that statute right there. They're telling you every court of Pennsylvania shall be a court of record, with all the qualities and incidents of a court of record at common law. Now you got all the elements of a court of record up there, and these little courts, they want you to come in for traffic citations or sewer authority citations or mass citations. We all know that they're not operating according to the courts of record elements. So if they're not operating according to the courts of record elements, those 6 elements, and like I did with the traffic court media, I told them, you're not a court of Pennsylvania. You can't be a court of Pennsylvania. By definition, you're not a court of Pennsylvania. So, sir, I don't understand and I don't acknowledge your jurisdiction because you must be a private court. Because you're not a court of Pennsylvania, so then you must be a private foreign court. And I have no intention of stepping into that court, and we're going to tell you why you don't step into that court. But I have no intention of stepping into that court. So that's another thing you bang them over the head with. Hey, every court of this state is a court of record. Here's the elements of a court of record. Your court does not proceed according to these elements of a court of record. And the main element is moves according to the common law. So, sir, or gentlemen, or whoever, I can't come into your court. Not only can I not come into your court, because if I came into your court, I'd be waiving multiple constitutionally secured God-given rights. If I came into your court, I'd be waiving my rights. I don't waive my rights ever. And number two, I wouldn't come into your court. If I came into your court, I would be contributing the crimes that you people have already committed against me. And now you want to, and you're continuing to commit against me right now. And now you want me to come into your court so you can commit more crimes against me? No thanks. I'm going to stand on my affidavits, and I'm going to stand on my claim, and I'm going to stand on my bar grievances that are going to be flying around. And I'm going to become, instead of becoming the hunted, I'm going to become the hunter against you guys. I'm going to make you guys run from me because I'm going to attack your insurance. And I'm going to show you your liability, your personal liability, which means out of your pocket. Because if I bring something against an attorney and he's outside of he's in non-compliant with the laws and the Constitution, that insurance company might drop him in a heartbeat right there. Well, now I'm still moving a claim against this guy. So if I get a judgment against this guy, he better have deep pockets to pay this claim, or he's going to go bankrupt. Depending on the size of my claim. I know people out there that I talk to, that I work with, they got tens of millions of dollars of claims out there against people. And man, if they get judgments on those, that insurance company might, when push comes to shove, when that suit gets filed against them, and that insurance company starts looking at what's going on, they may drop that person like a hot potato and say, we're not covering you here. You're in non-compliance of the law, the Constitution, these codes. You're in non-compliance, and we're not going to cover you. So that means that individual, that attorney, or whoever's coming against you, they have full liability. They could lose everything they have because now they don't have an insurance company to catch them. Said they better have real deep pockets. So suddenly when you start moving like this, they become less worried about you and your $150 traffic citation, and they're now worried about keeping their insurance and their careers. Because you walk them down the line after this. We'll walk them down the line even after we file these claims against them and these bar grievances. And next we'll walk them down the state and federal criminal complaints. And my God, if one of those sticks, state or federal criminal complaint, they may never work again. They're definitely not going to work for government. And if they've got a crime on their record, then they're felons. And they're going to have trouble getting a job somewhere else. A decent paying job they're going to have trouble getting because they got a record. So suddenly when you start moving against these people like this, you become a threat to them. You become a threat to their existence, their living. And listen, don't feel bad about it, and don't feel sympathetic, because they have no sympathy for you. They'll rob and steal everything that you have. That's how these people are, especially the Bar Association members. So listen, like I said, you don't get to push me into a fight and then dictate the rules of how I'm going to fight you. And I'm not going to let you use your rules of civil procedure that were created by the legal society, that are only for the legal society. I'm not going to let those rules of civil procedure tie my right hand behind my back, and you tell me, here, you got to fight me with your left hand. No. If we get in a fight, and I'm sorry, if you don't like the ferocity of how I fight and the viciousness of how I fight, then you shouldn't be in the fight. Get out. You better get out of the fight, because guess what? It's going to get much, much worse for you. And that's the purpose of why we're filing this paperwork and why we're moving like this. Now, here's the definition of common law. The common law is that which derives its force and authority from universal consent and immemorial practice of the people. It has never received the sanction of the legislature. Well, the legislature can't sanction anything according to the common law. Common law has nothing to do with the legislature. Okay, legislature operates by statute. Written law, the legislature operates by. Well, we know that the common law is an unwritten law. So anything the legislature does is written, has nothing to do with common law. And they could never change anything about the common law, the legislature. So it doesn't matter. That's why they can't sanction anything regarding the common law. They have no control over the common law. It's not up to them to decide what the common law is. They have no authority over that. So it states, it has never received sanction of the legislature by an express act. No kidding. Which is the criterion by which it is distinguished from the statutory law, from statute law. See what they just said here? Which is the criterion by which it is distinguished from the statute law. In other words, common law not written down, legislative law, which is statute law. Everything the legislature does is statute law. So it has never been reduced to writing. It can't be reduced to writing. If it was reduced to writing, it wouldn't be common law. Common law is common sense. So by this expression, however, it is not meant that all those laws are at present merely oral or communicated from former ages to the present solely by word of mouth, but that evidence of our common law is contained in our books of reports and depends on the general practice and judicial adjudications of our courts. Now, this is a lie, okay? The common law, and I wanted to put this out there because I want you to see what they're doing, what they're changing online. This is a complete fraud, okay? Look what they wrote here. They're trying to say, hey, just because it's not written down, but hey, look, we got books and reports and we got judicial adjudications of our courts. So that acts as common law. See this? This is legal society rubbish. This is bar association rubbish, okay? This is their way to hone in and defeat the common law. So they're trying to claim, now think about this. Their judicial adjudications that are made by statutory law, under statutory law, is now going to influence the common law. They're trying to claim, look, just because it's not, just because it's oral, it's not written down, our stuff counts. No, it doesn't, okay? This is what they're doing. And this is why, even in Black's Law Dictionary, I think after the 4th edition, they start changing words and they stop citing cases, I believe. A lot of cases. Like, you go back from edition 4 to previous, they would cite actual case laws that refer to the definitions. And a lot of the definitions from like 5 on from Black's Law got changed. And they did away with a lot of the court citings because people woke up, a lot of people, and they were citing and using this stuff. Well, they don't want that, and they even changed the definitions of a court of record from after edition 4 on, and they made it less stringent of what a court of record is. Just because they changed it doesn't make it so, okay? And just because they state things like this doesn't make it so. This is the most illogical thing you'll ever see. How can something create that like judicial adjudications? Well, we all know these judicial adjudications. These are not common law courts these are being made in. These are made in statutory courts. So how can a statutory court now affect the common law? It can't, okay? It's a ridiculous claim. So be aware when you see this stuff. Just because something is in writing, go dig a little deeper and find out really what the common law is. Because the common law is it's the people's customs, okay? Basically, it's how they do things. That's the common law. The common law is don't steal from your neighbor, don't harm or damage your neighbor. These are basic things, that don't have to be reduced to writing. So just because they say it doesn't make it so. Now, just as we have a hierarchy with God created man created government created corporations created judges and attorneys, and they created plaintiffs and defendants. How about that? So that's why they tag you with that title defendant, so that they can lower you below the judge or under government, and the judge controls defendants and plaintiffs. So great. Okay, so now we know that. Let's go look at the supremacy clause. This is the killer for them. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. That means for them. Remember, the Constitution, we're not a signatory to the Constitution. We're not a party to the Constitution. The Constitution is not applicable to us. All the Constitution is, it's a rule book for those that call themselves government. All right. What the Constitution does is it was meant to secure your God-given rights. It puts no duties or obligations upon you, the Constitution. And anyone that cites the Constitution against you, and I've had attorneys try and do it to me, they have no idea what they're talking about, or they think you're too dumb to understand that piece of paper that you're not a signatory to, you're not a party to, doesn't apply to you. It applies to them. Hence, why do you think they have oaths? If that paper applied to all of us, if that paper meant all of us, then why would these people be swearing oaths to the Constitution? So that piece of paper, that Constitution, applies to them. But look, let's go read this again. Which shall be made under the authority of the United States shall be the supreme law of the land, and the judges, these petty Fagerscheister judges, in every state shall be bound thereby. Bound means you don't have an option. You're bound by that federal Constitution. And look, anything in the Constitution or laws of any state to the contrary, notwithstanding. That means even the state Constitution. If the state Constitution is in conflict with the federal Constitution wins. Supremacy clause, okay? So we already know that the hierarchy is federal Constitution, state Constitution, and then under the state Constitution are laws, statutes, codes, and ordinances of these corporations, Commonwealth of Pennsylvania, so everything, there's a hierarchy to it. So anything contrary to the federal Constitution, just think of that ladder. Federal Constitution, state Constitution, and then third on there, law, statutes, codes, ordinances. So if it's third down on the ladder, the law, statutes, codes, and ordinances, isn't the mass violation, isn't that like an ordinance or something, or a mandate? They're ordinances. So an ordinance can't trump the federal Constitution. Can't happen. Supremacy clause. Anything in conflict is notwithstanding. So if you have any kind of citation, or even traffic citation, or a mass citation, or a tax citation, it's in conflict with the federal Constitution. So it's notwithstanding. And if you set this up properly with your affidavits, and you reference this properly with your affidavits, you put them in a real bad position here, because they're not going to be able to answer your affidavits. So I said there's a hierarchy to law: federal Constitution, state Constitution, and then the state of or Commonwealth of, and that's the third down the line, the hierarchy: the law, statutes, codes, and ordinances, mass citations, traffic citations. That's where they're at. They're down here at number 3. They're trying to take number 3 and jump over number 1. Well, notwithstanding, you can't. And then corporate policies are even below that. That's Walmart's policies, Target's policies. These are corporate policies. You got to wear a mask to come in this public accommodation. So they're trying to take number 4 and they're trying to jump number 1. I don't think so. It's not going to work. And if you sue them properly and you set your paperwork up properly, they're never going to be able to come into court and claim that their corporate policies trump the federal Constitution. It's not going to happen. Let's look at Amendment 6 and Amendment 7. These are sort of sister and brother to each other. Think about amendments. Amendment 6 deals with criminal actions. We looked at there's only 2 types of actions: civil and criminal. So Amendment 6 deals with criminal matters, criminal prosecutions. Amendment 7 deals with civil matters, generally contract law. It's got to be contract law. Somebody that had to do their obligation to perform for somebody else and didn't. That's what Amendment 7 addresses. Amendment 6 deals with actually real crimes. Okay, so Amendment 6 states, in all criminal prosecutions, the accused shall enjoy the right to a speedy public trial. Man, I'm looking at what's going on with this COVID nonsense. I'm not seeing speedy trials. I'm seeing things taking a ridiculous amount of time. So with some of those proceedings, go look up their own statutes and see what their time limits are on in some of these proceedings. You can knock some of these things out right away with just not giving you a speedy trial, because some of them actually in their statute state, but like certain time that the action has to be adjudicated. And if it's longer than that, then they've got to throw the action out. And look, by an impartial jury of the state and district wherein the crime shall have been committed. Now, we know what a crime is, right? It's crimes against a man or woman. You harmed or damaged somebody. You didn't harm or damage the Commonwealth of Pennsylvania, okay? So there's got to be a real crime. And look, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation. Why do you want me to come into your court? I don't understand. There's no damaged party here. There's no verified claim before the court. That's the nature and cause of the accusation. You have a right to know the nature and cause of the accusation. So that's another thing you could state in your paperwork, your affidavit of fact. I see there's no listing here of the nature and cause of this action that you're trying to bring against me, because there's never a damaged party and there's never a verified claim before the court. And look, to be confronted with the witnesses against him. So if the cops come in and come in after you for a mass violation or a traffic citation, who's he a witness for? Is he a witness for the fiction? Yeah, he's a witness for a fiction. He's claiming he's a witness for the people who are the Commonwealth of Pennsylvania. Okay? Well, we know that's fraud. So he's not a witness to anything. And he's got other things going on. He's got major problems here when he starts to make a claim that he could give you that ticket or that citation, because right off the bat, he's made legal determinations about you already. By just looking at you and your physical place of where you are, he's made a determination that he has jurisdiction over you. Now, we just covered jurisdiction up there, how courts attempt to get jurisdiction, about personal and subject matter jurisdiction. Did this guy take you through this process to determine jurisdiction? Did he send a process server to you? Did he show he has any standing in this matter? No. So, guess what he did? He just assumed he had jurisdiction over you. He don't have it. He never had personal jurisdiction. He never had subject matter jurisdiction over you. And let's go over this a little more. Look, to be confronted with the witness against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. Read that. Assistance of counsel for his defense. Do you see the word attorney in there, or lawyer anywhere? I'm looking here. I don't see attorney. I don't see lawyer anywhere. And, assistance of counsel. That could be your buddy, your family member. So when these judges tell you have to have a license to practice law in this state, bull, okay? That's corporate bull. That's corporate statute bull, okay? The only reason he's telling you that, because that's under their rules of civil procedure that state that. And here's the dirty secret. Neither the judge or neither the attorney has a law to practice license, has a license to practice law. Any license they got was from the Bar Association. The Bar Association is a private association. It's not a state association. The state licenses things, not a private organization. Like McDonald's doesn't license things, okay? They can license things for their business, but they can't license things for other people. Same thing with the Bar Association. They can't license things for other people. They can license things for their employees, their bar members, but they can't license things for you and me, okay? So it's a ridiculous claim for that cross-dresser to sit up there and claim that the legal society can create these things called rules of civil procedure, and because of their rules, that they can determine that you have to hire one of them. Boy, look at that rule. In other words, the group that created this rule has a rule that you have to hire one of their pettifogger shysters. You see a conflict of interest here? You got to hire one of our guys. Come on, man. This thing's, when you start to look at this stuff and break it down, if it wasn't so tragic, it's absolutely hilarious when you start to see the matrix for what it is, the real process. Here, we're going to create this rule. You got to hire our guy and our girl. Come on, man. Let's wake up here. Bang them over the head with this stuff. So, I had Ryan, the Marine who I had helped. He was helping his brother the other day, and there was one of them Zoom meetings, and he knows not to do a Zoom meeting, but his brother decided at the last minute to fight this, and he really had no other choice. So they rushed in, get this, they rushed an affidavit of status into the matter, and they faxed it in like 10 minutes before the hearing. So his brother's reading the affidavit of status under the court record. A quarter way through it, they mute him. They muted his mic. In other words, they didn't want him to get the affidavit of status on the court record. All right? And then further in the proceeding, the judge, Ryan jumps in, and the judge says, who are you? And Ryan said, I'm assistant of counsel. And the judge said, are you an attorney? He said, no, sir, I'm assistant of counsel. And the pettifogger shyster judge said, not in this state. You got to have a license to practice law. Well, the judge don't have the license. The attorney don't have the license. The only thing that the attorney has is his bar card. That's his membership to the private association called the bar. That's not a license. Like if I join a private club, I can't use their membership as authority to do something. That's not a license for me to do something. It's a membership to the club. It's not a license. So the attorney doesn't have a license. Neither does the judge. So Ryan said, "Well, sir," he said, "I'm not subject to the rules of civil procedure," and that sent the judge flying off the handle. That was it, and he banged it right on the head. Sir, I'm not subject to the rules of civil procedure. I can be assistance of counsel. I'm not following your rules of civil procedure. And when you can snap back, when you get things down to that point, you become a potent force when you're either in the court or in your paperwork. Because now they're going to start to learn that this person knows, I mean, don't say person, this man or woman knows a little something here. They might be dangerous. Then let's look at Amendment 7. So for all the pettifogger, the shyster judges and attorneys to tell you, well, we don't do things by the common law anymore. Everything's by statute. And I've heard this actually said by people, by attorneys. I've heard it said by judges. Well, gee, I must have missed something. They must have repealed the 7th Amendment without my knowledge, because it actually states, in suits of common law, which I say common law means civil matters. These are not crimes, common law. I mean, that in suits of common law means sort of like a civil matter. In suits of common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. There's your friend right there. The right of trial by jury. Because when you go into these little traffic citations things, a lot of these traffic things, there's no jury here. They don't want to seat no jury because they want to. This is a slaughter line. They want you to come in, bang you over the head with the mallet, and bring the next one in. You're a battery. You're just they're charging you. They're charging your account. They're banging you over the head, and they're moving the next one in. So they don't want to give you no jury trial. That's expensive for them to get a jury, seat a jury, have a jury trial, the time involved in that. They're going to seat a jury to get a $150 ticket, a traffic ticket? No. So right there you could cite, hey, I listen, I can't come into your kangaroo court. You don't say kangaroo, but you're thinking it when you're writing it. I can't come into your kangaroo court because I'd be waiving my right to a trial by jury. I don't see anywhere on here where I have there's a trial by jury in your proceeding. So I'm not going to waive my rights. I'm not going to do that. And look, this is key. And no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. That means not even the Supreme Court can re-examine a fact decided by a common law court. And this is the line that's been confusing a lot of people, because this sounds like there's an appeal. Because remember, it says re-examine, and it says no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Well, there is no appeal process in common law. Now, that doesn't mean there's no remedy. That just means there's no appeal process. Appeal process this is statutory stuff. This is stuff that they've created by statute for their courts. Okay, and there is a remedy by common law. We're going to show you that there, and we're going to clear this line up because I'm getting a lot of messages on this. People saying, well, what about this? Because this sounds like an appeal. It is let's call it a pseudo appeal, because we're going to show you how it works. So look, there's no appeal process in common law court. So think of the common law as the customs and traditions of the people. That's what the common law is. It's all based on the customs and traditions of the people. So they say there was a court that constituted or proceeded according to the common law. There was a common law court set up. And say that the process of the court was defective. So, for instance, there's a key fact that was presented to that jury that was later found out to have been falsified. Someone purposely falsified that fact by the party that used it. So look, there exists no common law appeal process. There's no common law appeal process that injured party can go through. Only another court that's constituted to be a common law court can re-examine that fact. So look, not even the Supreme Court can go re-examine that fact determined by that common law court. So what would happen is the party that was wrong by the other party, that had the falsified fact information used against them, they'd create their own court of record. Their own court proceeding, just like the one that was brought against them. They'd create their own court of record, and that would proceed according to the common law, and they would seek remedy for that wrong, that falsified document. They would seek remedy for that wrong, which in effect would act as an appeal, even though it's a whole new proceeding. It's a whole totally new proceeding that's being brought. It's not an appeal, because an appeal is attached to the original proceeding. The appeal court kicks it back to the original court. But you don't do that with common law. You would just bring a whole new proceeding, and just like anything in common law, that man or woman damaged you by falsifying that fact. So you would have standing to bring a proceeding against that man or woman that harmed you, that damaged you. And contempt of court. It's funny, man. I found this, and these courts. I mean, they're so quick that these judges are clueless. They think they can just hold anyone for contempt of court. Listen, if you're standing up for your rights, and this pettifogger shyster's there, and he's claiming that if you keep talking, he's going to hold you in contempt. The first thing should come out of your mouth, it should be, sir, are you stating that for me exercising my rights, that you're going to hold me in contempt of court? Because that's exactly what he's doing. And don't go off of that. Sir, are you claiming if I exercise my rights in this court, you're going to hold me in contempt of court? Stick on that. Keep jamming it 3 times if you have to. Bang it against him. Sir, are you claiming because I'm exercising my rights, you're going to hold me in contempt? Because you put him in a real bad position when you frame that way. Because that's exactly what he's doing. He's trying to shut you up because you're making points that are going to damage his buddy's case, his fellow bar member. You're going to damage that case, and he don't want that to happen. So he's got to shut you up. And just like Ryan's brother, as he was reading his affidavit of status quarter way through, they muted him because they didn't want that affidavit of status to get on the record because it's game over. Because now there's nobody to come against Ryan's brother's affidavit of status. Because now him reading that affidavit of status, he's reading it onto the court record. Remember what I keep telling you with affidavits, you file them into a proceeding. If you're filing them into an existing proceeding, in other words, one that you're already involved in, just because you file it into the court docket, it's not on the court record yet. Until you read it into the court record like Ryan's brother was doing, or you do the old Robert Fox trick, which is basically, it's my understanding I'm going to tell the truth in all matters. And should I not tell the truth in all matters, then I'm subject to the penalties of perjury. Having qualified my testimony, as you state, having qualified my testimony, I now include my affidavit and put it into the record as if stated in full herein, which means everything in that affidavit as if I stated it here in full is the truth, the whole truth, and nothing but the truth, so help me God. So now without reading every line of your affidavit of status, you just took your affidavit of status and you got it onto that court record. Because when you get that court transcript, if you get a printed copy of that court transcript, your words are on there. They're on the court record. You've incorporated that. You've told them I'm bringing my affidavit in as if I stated it here in full. So now your affidavit of status is on the court record. Now I got a problem with you. Because when I get my affidavits on the court record, I don't move. I'm not moving. If that judge wants to move by my affidavits, no, sir. No, I got unrebutted affidavits in this matter. You're in check right now, sir, until this guy over here, pettifogger shyster attorney, answers my affidavits. Or this Commonwealth of Pennsylvania grows a brain and a set of arms and gives me a response to my affidavit of status or my affidavit of facts. And so until one of these entities responds to my affidavit, I'm not moving in this matter. I don't need to move in this matter. My record's made already. I got my affidavit on the record. And what an affidavit then serves as when you get it on the record, it is testimony. It acts as court testimony. It's on the record. Now, the only way it can be rebutted is by the other party creating an affidavit and submitting their affidavit and challenging yours point for point. So if you've got 10 points in your affidavit, they've also got to create an affidavit and challenge all 10 points of yours. That's never going to happen. The fiction's not going to do it, and Mr. Attorney, attorneys don't answer affidavits. I tell you from first-hand knowledge, they don't answer affidavits. They run from affidavits. Okay? So I found this interesting. I found this for Pennsylvania. I think this is in Bouvier's dictionary, 1856 version. In some states, as in Pennsylvania, the power to punish for contempt is restricted. Look, restricted to offenses committed by the officers of the court. Are you an officer of the court? I'm not. I'm pretty sure you're not. So look, restricted to officers of the court. Or in its presence, which means you've got to be in front of them creating this contempt right before the court. It's not something you can do outside of court. Or in disobedience of its mandates, orders, or rules. But no one is guilty of a contempt for any publication made or act done out of the court. So it's got to be done before the court. And it says, which is not a violation of such lawful rules or orders or disobedience of its processes. You're not an officer of the court. I'm not an officer of the court. So these judges, they're throwing contempt around, and they really don't even know what they're doing. A lot of these judges. And listen, I know a gentleman. I spoke to a gentleman who's gotten millions of dollars in settlements, and he flat out says most of these judges are dumb as dirt. Okay, they're dumb as dirt, and you'll be surprised how much more you know than the attorneys. And they could take their listen. The way attorneys are taught, they're really not taught law. A lot of what they're taught is process. You know, how to do legal research for statutes and stuff, and legal process they're taught. They're not taught real law. So this whole common law thing and affidavits, they know what affidavits are, but either they're either the most, well, they probably are. They're unethical, because when you submit an affidavit against an attorney and he gives you just a letter back, that's not a response to your affidavit. So if you get a letter back from an attorney for your, in response to your affidavit, you didn't get a response back. He never responded to you. And if he ever brings up, well, I wrote back to Mr. Faggiola. No, sir, no, you didn't. I submitted an affidavit against you. And the only party that can rebut the affidavit is the party it was submitted against, and it must be rebutted point for point. Sir, you didn't give me an affidavit back. You gave me a letter, which means your letter is just nothing but your opinions, because you didn't swear under penalty of perjury of everything you wrote down on that document you sent to me. So everything you gave me, Petty Fagerscheister, is complete hearsay. It's nonsense. So you didn't give me an affidavit back? Everything you gave me is nonsense. Let's look at judges issuing pleas for you. Now, this is if you're stuck in a court and, we all know this move. Well, if you're not going to plea, I'm going to plea for you. Well, listen, judges will always issue a plea of not guilty for you. And he's doing that because of their statutes. That's in their statutes, that if you refuse the plea to the statute, that they can't even prove applies to you yet. But if you refuse to plead to this statute, that's like I said, if they can't even prove it applies to you yet, that's why I don't go into the courts. I'm not going to. It's like asking the rape victim, like they raped you once to get you to cause this controversy. That was a rape, whether it's a traffic stop, which is an arrest. So they raped you once, and now they want you to come into court so that they can rape you again. So I'm not going to subject myself to that. So they can't prove their statutes or have any applicability to you. So this is both illegal and unlawful. So what he'll do is, when he issues that plea for you, well, if you're not going to plea, I'm going to issue a plea for you of not guilty. Here's a very simple process you walk him through. There's nothing complicated here. Sir, have I appointed you my counsel? No. He's going to say no. He's got to say no. And if you don't want to answer, you keep asking him, sir, have I appointed you my counsel? If he don't answer a second time, sir, have I appointed you my counsel? And if he don't respond, say, after three failed responses, for the court record, the judge has stated no, I have not appointed him as counsel. So for the court record, I have not appointed John J. Whelan as my counsel. That's the judge. I don't call him judge. I call him by their name. Hey, John. Hey, Mary. So for the court record, I have not appointed John J. Whelan as my counsel in this matter. Given the fact, the ruling made by John J. Whelan of not guilty, because that's what he stated, I was not guilty, it can't be a plea. In other words, if I haven't made him my counsel, he can't issue pleas. Well, if he can't issue pleas and he made a ruling of not guilty, well, that can only be a judicial determination. It's got to be one or the other. He's either got to have power of attorney from me to act as my counsel, or he's making a judicial determination. Well, we know you don't have, I never gave him power of attorney. He's got no document proving I gave him power of attorney. No statute can give him a power of attorney to act for me. That's just a piece of paper. That piece of paper doesn't give him power of attorney to act for me. So then when he ruled not guilty, that must be a judicial determination. It's got to be. It's got to be one or the other. So I say, hey, you know what? Thank you. Goodbye. And I walk out of court. We're done. You've made a judicial determination, not guilty. What you going to say? No, I issued a plea for you. Great. Can you show me the document where I've given you authority as my power of attorney? That document don't exist. And now what he did with this little slick thing he thinks he's going to do is a plea for you, that should get him a judicial complaint filed against him. And a lot of these judges maintain their bar numbers, their bar cards. Go find out if he's got his bar number still, and go file a bar grievance against him. So now you rung the insurance bell twice for him. Judicial complaint, bar grievance, and you start filing this stuff. Like I would leave court and I file an affidavit that this guy just committed a crime, because I never appointed this guy. I never gave this guy the power of attorney to be my counsel, and he's over there issuing pleas for me. That's a crime. Okay, so and because he don't have authority to issue pleas for me, and he made a determination of not guilty, that must be the determination of the court that I'm not guilty. Thank you. Goodbye. It's one or the other. So that's just a little slick way to get them, to sort of stick it in their face a little bit. So, like I said, don't get overwhelmed with this stuff. Don't think you have to. I see people log onto the Telegram group and say, "Oh, there's so much to learn, so much of this stuff, so much of this stuff." Like I said, you're learning tools. Everything's a little tool. And these lessons, the how to stay out of the court number 1 and how to stay out of the court number 2, these are tools within a tool, basically. There's all little pieces in here, separate tools that make up a bigger tool, which is how to stay out of the court. That's your goal, is to stay out of the court. So go dig through your state documents, your state constitutions, and look for things that state your courts are courts of record, or if you could find that, and you'll find that in a lot of states. That's blatant proof that these are courts of record, and only a common law court is a court of record. In other words, their statutory court, that can never be a court of record. Can't be. Doesn't meet the court of record elements. So if your state's saying it's a court of record, what they're screaming at you is it's a common law court. So when you see court of record in your state, common law court. And now we know the elements of a court of record. And if they want you to go into that court, you're going to cite all this stuff I have up there. That's why go down to my traffic citation folder and look for my response to traffic citation documents. Because in those documents, you're going to see pretty much everything I just covered here. And I was supposed to have a hearing on March 1st, and I basically filed I filed every document in that document thing I put up there. And we're now at April 2nd, that's over a month, and I've got no letter from this court, and I've got no police officers show up to my door to arrest me. So, must have made an impression of some type against Mr. Andrew Goldberg, because everything I just taught you here, I stuck back in his face, and I did worse. I filed a mail fraud complaint against him, and I gave him a copy of it, and I filed a judicial complaint against him, and I gave him a copy of it. Like I said, I like to do movie analogies, and to me it's like Sonny in the Bronx Tale. When they beat the bikers up, and they throw them out of the bar, and they're out on the street, and they're kicking the heck out of them. When they're done the fight, Sonny walks up to the one guy, picks his head up, he grabs him by the hair, he picks his head up, and he turns his head to look in his face, and he said, "Look at me, I did this to you. I did this to you." And that's what I'm doing when I'm sending them copies of the mail fraud complaint and copy of the judicial complaint. I want them to know I did this to you. So even if the parties I filed these with, the post office and the judicial board, his buddies, or that they'll try and protect them, even if they don't move, I still want the judge, Mr. Goldberg there, Andrew Goldberg, to know I filed these things against you, because he don't know what's going to happen with those things, and he may start to get worried, and it sounds like he must be a little worried, because he would have sent a gang of thugs to come kidnap me, and that's not going to happen, because any thug that comes after me knows, look what I just did to this guy with the little process. Like, they don't know where I'm going to end with this, and I'm not done with Mr. Goldberg, and just like you're not going to be done with these people, because I can take Mr. Goldberg through my process. I can then file state and federal criminal complaints against Mr. Goldberg. And guess what happens if I get one of those criminal complaints to stick to Mr. Goldberg? Mr. Goldberg's not a judge no more. And when I start filing these state and criminal complaints, think about this. Those state and criminal complaints you file against these people, I'm guaranteeing almost that I guarantee their insurance policies, there's something in that policy that'll state, if you have criminal complaints filed against you, you've got to notify the insurance company. Would have to, for liability reasons. Because if you're filing criminal complaints against them, that insurance company wants to know what's going on. Because even though they're criminal complaints, and you don't get to prosecute with the criminal complaint. Unfortunately, that's left up to the government entities. But what you're doing is you're making waves with them criminal complaints. Trust me, phone calls get made and visits get made, and it shakes a lot of people up. So you file them anyway. Even though they're probably not going to do nothing with them, that's fine. You still file them. But when those criminal complaints get filed, I guarantee in their insurance policies, there's things in those insurance policies that they've got to notify the insurance company that they had criminal complaints filed against them. Well, guess what that's going to do to their insurance? Think about what just happened with this attorney or this judge. You filed, if it's a judge, let's look at him. You filed a bar grievance against him. That's not going to be good for his insurance. You filed a judicial complaint against him. That's not good for his insurance. You filed a notice of claim, hopefully a substantial notice of claim, yes, for a substantial amount of money against the judge. Insurance company's not going to be happy about that. And now you're filing state criminal complaints. Oh, they're not going to be happy about that also. And then you file federal criminal complaints. They're not going to be happy with that also. And then the cherry on top, when it's time to end the game, you file a judicial claim against them, a formal judicial claim in a court, and you sue him, his corrupt rear end. You sue him. Okay, I don't want to say the word. I don't want to get censored on YouTube here. So, but yeah, you sue him, and when that suit hits, oh, they're definitely not going to be happy with Mr. Attorney and Mr. Judge, and by the time you walk him through that process, that 6-step process, he might not have insurance by the time you hit that step 6, because all you're doing is laying more liability on his lap, and this is how you keep these people off you. This is, you stop becoming the defendant. All your life you're taught to be the defendant. Stop becoming the defendant, because they're hunting you as the defendant. So when they come after you, you become the hunter. And when your paperwork's constituted properly and set up properly, they're going to learn real quick that you're not the hunted. Uh-oh, this is a hunter coming after me. Not already hunting me now. They're going after my insurance. And God forbid I lose my insurance. I can't work. And you run after people and show them their liability. They run from you. And this is what we haven't done. For all, through like I said, schooling and media and families, whatever, we're told to go get a pettifogger shyster attorney to defend us, and that's like putting your arms up and letting somebody just keep punching you, repeatedly punching you, and trying. How can you win a fight if you don't punch? You're never going to win a fight unless you can't punch. Unless the guy has a heart attack, you're not going to win the fight. You got to punch back, and that's what this process is. So this is why. Follow this process. Look at part 1 and part 2, and look at my paperwork. It's pretty much all laid out there for you. And right away, I'm going to file those affidavits into this court. And listen, here's another thing I want to clarify. When they file this paperwork against you, they're going to give it a case number. Do not use their case number. Do not use their forms to file your paperwork against them. Okay. Whatever you do, God forbid, don't file into this case. If you file paperwork back into the case, you now have given the case life. You've charged the case. You've given it validity. So what I do is that's one of the reasons I do that notice of deficiencies and irregularities document. Because at no point in my documents will you see me reference their specific case, because I'm not going to give it any validity. But I'm going to take their document, mark it up like I talked about earlier, and I'm going to attach it to the affidavits and the notice of claims that are going against them. Because then they know exactly what matter I'm referencing. I didn't have to put it in my paperwork. It's on their paperwork, and their paperwork's all been marked up for fraud. So get this process down, and like I said, make sure you know what you're doing. Make sure you understand this stuff and can talk about what's in your paperwork. Like, I put stuff up there in my paperwork. Don't be like so many other dummies out there. They print something off the internet and they take it into court, and the judge will ask them something, and they're done because they don't understand the paperwork they brought into court. And that judge is going to learn right away. He's going to ask you a question. He's going to say, this guy printed this off the internet. He's got no clue what's going on here. If you understand that paperwork and you get in there and somebody challenges you on something and you're lucid and can back it up, they're going to respect you and they're going to back off you, because they're a little worried about, hey, this man or woman might know something. And they're either going to respect you or they're going to fear you. Because if you start, you set your process up right, bar grievances, notice of claims, state and federal criminal complaints, they're going to start to fear you because now you're a threat to their career. They're coming after you for some $150 mass citation. Now you're threatening their careers by coming after their insurance. And this is how you, I don't want to use the word defend yourself, but let's put it this way. This is how you protect yourself against bullies, against criminals and thieves. This is how you protect yourself. So, like I said, just take this little piece at a time. Don't worry about the whole big picture. Little piece at a time. I want to start trying to glue this together in your head. I'm trying to unprogram you because listen, I was programmed for years. I was one of the average monkeys that I didn't know any better. I believed Commonwealth of Pennsylvania. I guess this attorney could speak for the Commonwealth. I never gave it any thought until I got pushed into this, and then I started really looking at the truth of what's going on. So don't be like the average monkey that just takes something printed off the internet and runs into court and or tries to submit it and has no idea what's on it. When you download my documents, read them and make sure you understand them. If you don't understand something on one of the documents, you got about 1,800 people right now in the Telegram group. Go say, Alphonse put this in here. I don't really understand what he means by this. And I'll guarantee you, there's some really high quality people up there in the Telegram group. They're going to basically tell you, here's what he's saying, blah, 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 blah. So that's why I like the Telegram group more than answering emails and even responding to stuff on the website, the forums, because it's like real time. It's interaction because you can get up there and you can almost get instant help with something. You post something in a forum, it's going to sit there until somebody looks at it. And I know for me, I'm still getting like buried with emails. I don't want to look at the forums right now, the forums on the website. And that's another thing I want to hit real quick. Other people are a little confused about this. Where's it at here? Let the site come back up. All right, so I replaced the video player with this new video player, and it's funny. And listen, it's not obvious for anybody to see, so I don't blame them for emailing me. But people are saying, "Oh, there's only one video up there. What happened to the videos?" And it is a little. It's not very intuitive. But look, see this little hamburger thing up there? Here's all the videos up here. All right, they're all in the playlist there. So each time I do a new video, I'll stick it in the playlist, and it'll automatically pop up on the site. Because I'm trying to streamline this process as much as possible, because the more I can streamline it, the more I can do sort of videos like this. And the more clunky and time consuming something is, that's why these are not like high production videos with music intros and I don't have time for that, okay? Listen, I'm a recording engineer producer. I can do some really nice stuff. I can edit some really nice videos. But if I do that, it's going to take me 3, 4, 5 days to get the video out. And in that 3, 4, 5 days, geez, maybe I can get 4 or 5 videos done by just doing them like this. So that's why I did that. I'm trying to streamline the process. And as I said, any ideas you guys got on how to streamline things, I'm open to I'm open to ideas, because the less work for me, the better it is. It frees more of my time up to do things that are helpful, relevant, instead of doing just clunky things like having to upload videos to the website also. And I'm going to also back these up on Odyssey. So I heard a lot of people worried about videos being taken down, because we all know the YouTube police are out there, and it's just a matter of time before they're going to pull my my site down. It's just a matter of time. It's going to be the right person complaining, and YouTube will flinch and they'll pull it down. So I'm going to back them up on Odyssey also. And I got them backed up here anyway. If worst comes to worst, it'd be a hassle to upload them again, but I got them all, and I'm going to back them up on Odyssey. So I just wanted to point that out. They are there. Just hit that little hamburger tool, and they're all right there for you. And this is actually good. This gets more plays on videos, and not that it's any great revenue stream, but hey, if YouTube's going to make money off of my videos that I have up there, well, then I should get a small piece of it, right? So it's better if you guys are watching videos on here that it's going to make YouTube have to give me some money. So that, that's even better. It creates less work, and it could create a little more of a revenue stream. Not much, just enough to buy maybe a case of beer here and there. That's about it. It's not a lot of money, trust me. But so that's why this is up there, and that's why you have this playlist here. So that's pretty much it for now. I hope this was helpful. I hope this is starting to unprogram you, because like I said, we've all been programmed, and I hope this is starting to glue things together, and you're starting to see the overall process. Why am I doing affidavits, and why am I doing notice of claims, and why am I doing bar grievances and judicial complaints? Now you're starting to see the power of this process, because look what we're really actually fighting them back with. We're really not fighting them back with a lot of law stuff beyond affidavits, what an affidavit is, what it stands for. But look, we're banging them over the head with their process. We just took their process apart with these documents showing that these are not courts of record. These are foreign jurisdictions. These are private courts. So hopefully this will start to piece this all together for you. And I'd love to hear more success stories, because I think that I get the biggest kick for me is hearing you guys that'll send me an email or something, say, hey, I got this dropped, I got this kicked out. That's phenomenal. Just to know that I had a small influence on something like that. That something you learned from me that was helpful to you, that helped you in some way, helped you and your family, because that kept money in your pocket. It stopped these thieves and criminals from stealing from you. So that means a lot to me when I get those kind of stories from you. So that's about it for now. Like I said, don't let these people get you down. Don't get overwhelmed with this stuff. Just take it piece by piece, and don't let these people get you down. Take care. Bye-bye.